Hi, guys. This is Anna Lakin with Applegate Dillman Elder Law. And with me today, I have my colleague, Rachel Rode. And Rachel, why don't you introduce yourself and tell everyone a little bit about yourself?
Thank you so much for having me. First off, my name, as Anna mentioned, is Attorney Rachel Rode, and I am the Associate Attorney here at Applegate and Dillman. And the majority of my practice it focuses on guardianship and probate work specifically, but I do a lot of general litigation as well. And I've experienced multiple areas of the firm, but that's kind of where I have found my niche and what I do the majority of my work. So that's kind of what we're here to talk to you about today.
Yeah, so today we are going to begin our series on guardianship because February is Guardianship Month. And I think it's important when we discuss guardianship or even power of attorney, we have to define who is an incapacitated individual. So, can you answer that?
Absolutely. So, first off, the thing I want to say is that incapacity can come and go. It can ebb and flow just as much as you or I may have our good days where we are productive, we're getting a lot of things done, all of our synapses are firing like they should be. And then there are other days where we're just a little sluggish. Obviously, that's a real life example, but capacity is very much the same way, especially as a person starts to age. So, a person who is incapacitated has often been diagnosed with some sort of a mental disability of some kind, whether that be dementia or Alzheimer's. Um, Sometimes they have more clarity than others, but this often plays into whether or not they can understand what they are doing in real time and how many decisions they can make for themselves. So do they understand how to handle finances? Do they understand what they want to wear in a given day? So I'm not saying that this incapacity doesn't allow them to make any decisions or prevents them from that, but usually those higher level decisions people struggle with once they've become incapacitated.
No, that makes sense. Absolutely. So, I know that there have been times when there was a capacity question with family members that have been a part of our firm. And I think it's always important to recognize that, well, like you said, that capacity can ebb and flow. And so, answer this question. If mom is not uh, fully mentally there first thing in the morning and late at night, does that mean she's completely incapacitated, even if she has a good, let's say, 8 hours during the day or 6 hours during the day?
Right, absolutely not. In our particular case, we're looking at a lot of times we see this when it comes time to sign documents. So mom wants to create either a power of attorney or a new will or update her trust, whatever that is. She obviously has to have the legal capacity to understand what she's signing. And so, in that time, when she comes into the office, we would run through like a battery of questions just to kind of make sure and give ourselves the comfort in knowing that mom knows what she's doing. This is what mom wants to do. Because no, like you said, she might have Alzheimer's with some sundowners in there as well. And mornings and evenings are not her strong suit, but that doesn't mean that from 10 in the morning to 4 in the afternoon, she's not good to go. So kind of as it ebbs and flows, it can be a real time thing. That in this moment right now on this date she knows exactly what's going on and what she's doing.
No, that makes sense. So when we talk about guardianship, I think a lot of times it gets misconstrued with powers of attorney. And it's hard to, as a consumer, to draw that line between what is the difference between power of attorney and guardianship. Can you clarify those differences?
Absolutely. So first off, the biggest two differences I see are who grants the authority for the person with the power, and a public versus private decision is kind of those two different biggest differences that I see. So I'll start with the first one. So who is granting that authority? Well, in a power of attorney, mom or dad or whomever is the one choosing their power of attorney, whomever they want to help them with finances or healthcare decisions, they're the ones who pick. So in my case, not too long ago, my mom decided she wanted to put powers of attorney in place, and she was the one making that decision and granting that authority to whomever she chose as her power of attorney. Whereas with a guardianship, the courts are the ones that are granting the authority to be able to help and act on the behalf of the incapacitated person. So you have to apply to the courts to be appointed. So the courts are the ones that are making that ultimate decision, whereas with a power of attorney, the individual is making that decision. And the second major difference, in my personal opinion, kind of comes back to those same reasons, and that is the public versus private nature of things. So with a power of attorney appointment, that is something that can be made amongst a family. Obviously, you'll need legal documents to effectuate that, but you don't have to tell your local court, hey, I want to name my son as my power of attorney. To be quite frank, they have entirely too many things to do to worry about that sort of thing. So that's a very private decision that you can make within and among your family or friends or whomever it is that you're naming. But with respect to a guardianship, that is a public forum for starts. So that's within the court system. And so all of those documents are accessible by the public. So there's just that line of public versus private. And so if you want to kind of keep things in and among the family, powers of attorney, if able to be executed, are probably the better way to go. Do those nuanced differences kind of make sense?
Yeah, definitely. I think not only do you want to make it in private, but I think there's like that declaration of incapacity that has to be made publicly. That
Right.
I don't know if I really would want to share that with the world. That I
Right.
don't care how old I am or what's going on. I don't really want it to be, out there for anyone to see that
Absolutely.
this is what I'm experiencing.
And
That's
it's
me.
it's kind of twofold, because a physician has to find you incapacitated to kind of even put you in that bracket of needing a guardianship, and then the court makes a finding and they put it in an order that says so and so is incapacitated and in need of a guardian. It's just part of the process, and like you said, you don't necessarily want everybody to know that. So there, that's probably the biggest difference in my opinion.
Right. Yeah, absolutely. So, powers of attorney um, is if I sign a document that just says power of attorney at the top, do I have authority to do everything? Are there different types of power of attorney? I think this gets confusing for a lot of people as well.
Right. That is a loaded question. So it's not just a one word answer, but yes to most of it. So your first question was, if I sign a document that says I'm power of attorney, can I do everything? Odds are probably not. So in our firm, we have two different kinds of powers of attorney, and most people handle this the same way. You have a power of attorney for financial decisions, and then you have power of attorney for healthcare decisions. And so those are the two different kinds of powers of attorney, and you can you can grant them to the same person, you can grant them to two different people. In some cases, folks decide that they've got two kids and they want them to serve as both their financial and healthcare powers of attorney, so that's also okay as well. But with respect to can you do everything, that comes back to the way the document is written and what's in there. So some general powers of attorney are very high level and don't give you a lot of power. These are the ones that we often see that folks get off the internet or go print out at a Staples or something like that. They're just not very thorough. Whereas people invariably come in to sign documents with us and they're like, my goodness, this is a lot of pages or a lot of paperwork. And as silly as that might sound, the reason it's that way is because it is so thorough. We regularly update our powers of attorney to ensure that they are in compliance with the new laws that go into effect every year. Sometimes the laws don't change much in the power of attorney realm, but sometimes they do. So we go back and do an audit and make sure everything is up to date and good to go. And so we do that with both financial and healthcare. So depending on what authority has been granted in that document will limit what you're allowed to do. Some of them can be very specific. Like I had one not too long ago that says, I give my son the authorization to deal with such and such bank account. So all he had the power to do was deal with that specific bank account. But you can give one that's much more wide ranging, that allows your power of attorney to sell property on your behalf, manage investments, do your general banking, pay bills, all of that sort of thing can be included. It just depends on how it's written.
So I have a question for you that we didn't plan for, so I apologize. But
Okay.
I was thinking about this because this happens a lot. So I'll use my family as an example. When my grandma was in Florida, she signed a power of attorney there so that somebody could take her to the doctor. She is in her 90s.
Right.
And so she's often not able to make big decisions for herself that are in her best interest. And then she signed a power of attorney in Mississippi, and then she signed one in Indiana, and just, traveling around to see her
Right.
kids. She has 5 kids. And so which one's the one that counts?
That is a complex question, more so than you may realize. So typically, each state will have a law that says a power of attorney, if properly executed in a different state, is valid and will be accepted in our state. However, usually when folks sign new powers of attorney, one of the first sentences states, "I revoke all prior powers of attorney," unless if they intentionally do not.
Right.
So if that intention was there, it's usually mentioned. This does not revoke such and such power of attorney that was executed on such and such a date. So typically, the easy answer, or the most honest answer for this particular set example is usually the most recent is the most valid, if you will, unless of course you go to read it and it says, "I didn't revoke any of those old ones, they all still work." So typically it's the most recent one that was executed.
That's a good answer. That makes sense.
Yeah.
So as you and I know, powers of attorney are a part of a packet of legal documents that we call advanced directives.
Absolutely.
What other documents are a part of advanced directives at Applegate and Dillman?
So as I kind of already touched on, there's the 2 types of powers of attorney. So you've got your financial, or the more worldly term is the general durable power of attorney, but really that boils down to handling finances. And then some folks call a healthcare power of attorney healthcare representative documents, but that's the one that allows someone to help you make healthcare decisions if the time comes when you no longer can. And then we also prepare a document that is basically a HIPAA release. And we prepare it so that it can be used at multiple locations by multiple physicians, so that in case a physician doesn't have their form, or you've become incapacitated and can no longer fill out their forms, well, you've got this one ready to go. And then we also do a living will. And a living will talks about the kind of care that you want at end of life. So it kind of poses a couple of different examples to get your brain thinking. If you are nearing end of life and are needing care, or the end is coming, I suppose, do you want to receive artificially supplied hydration and nutrition, or really what those focuses on? But Applegate and Dillman, we've kind of expanded that to kind of take on a couple of new areas in the last handful of years. The second one, same care needs, but you're in a vegetative state rather than end of life has been determined to be very near. And then most recently, with the onset of the coronavirus, we have expanded that to talk about what kind of care you might want if you find yourself in a hospital on a ventilator suffering from COVID. Because our clients kept coming to us and saying, "Hey, well, these are all fine, well, and great, but right now the thing that is plaguing us as a society the most is coronavirus. And what happens if I end up in a hospital in that situation? I might want to handle that differently than if I was nearing the very end of my life." And so we've kind of adjusted that living will to reflect those changes. And then the last piece of our puzzle that I think might be a little bit different than some other folks is what we call a funeral declaration. And I really like this document because kind of probes a conversation that may not be a lot of fun. And the only thing we ask folks if they decide to fill it out before they leave us is whether they want to be buried, cremated, or like entombed, that sort of thing. But there are sections on that document that say, at my funeral, I want, and then there's blanks, or I want to have my funeral at, and then there's blanks. And I think it just facilitates a conversation that may not be super comfortable to have, but I think it opens the door. So for instance, a really good family friend of ours passed away. I'd grown up with him. He was one of my mom's best friends. I was probably about 10 years old when he passed away. And they were from Franklin. So we were at a small funeral parlor down there. And he was a huge rock fan. Like that's the most understated sentence of the century. And so as we are kind of sitting and visiting with family and that sort of thing, over the loudspeaker in the funeral home is Led Zeppelin's Stairway to Heaven, the Eagles, like just all of the above. Anything you can think of that is rock was happening at this viewing. I mean, it was in the subdued tones, which was kind of funny and laughable in hindsight. But to this day, my mom will say, "Hey, will you play this song at my funeral?" And I'm like, "Mom, just get this sheet of paper out and write it down, because I'm not going to remember that." But I do like the fact that it facilitates that conversation. So those are kind of our packet of documents that we at Applegate and Dillman consider advanced directives.
And I know you answered this with respect to the difference between power of attorney and guardianship. And so you've talked about what's included in the advanced directive package. What is the difference if I complete my advanced directive package versus guardianship? Is it the same as the power of attorney?
Kind of. The hope is if you can make these designations in advance while you've got the capacity, you have taken the guesswork out of it. And you have nominated your people. You have been able to make that choice. Now, sometimes guardianship is still needed. You can't completely avoid it in some situations, but in the powers of attorney that we at Applegate and Dillman prepare, there's even a section that says, if I need a guardian, I want it to be so-and-so. Usually it's the person you took the time to nominate as your power of attorney. So sometimes guardianship's not always avoidable, but theoretically, if you've got the capacity and you can put these documents in place in advance, you can hopefully avoid guardianship, which is the whole goal, really, because you don't necessarily want to have to go through that court process.
Right. No, that makes sense. In a guardianship, let's say I didn't complete my advanced directives and there's been a guardian appointed, would they have to get court approval to execute those same decisions that are inside that advanced directive package?
To a degree. So with respect to guardianship court, the guardian has to get permission to do pretty much anything big. Yeah. So if the person that's under guardianship needs to move from their current residence into a facility or just to a smaller current residence because their house is too big, the guardian has to go to the court, get permission to move the person and sell the property. If the person needs a new vehicle, they can't still drive, but someone drives them in their new vehicle, the court has to grant the guardian permission to do those sorts of things. So a lot of those things could be taken care of with the powers granted under a power of attorney. So there's a huge difference. There is the cost savings. Right. Obviously, like I mentioned, sometimes guardianship isn't avoidable, but if it is, you're saving yourself considerable amounts of money if they can execute those documents in advance.
Yeah, no, that makes complete sense. And to the point of cost savings, at least at Applegate and Dillman, we generally function on a flat fee for things that are planning purposes. So things like power of attorney and advanced directives. Absolutely. Fortunately, in guardianship world, we can't do that because we can't foresee how often or all the nuances that are going to come of guardianship court. We don't know what that looks like. Exactly. And so from a cost saving standpoint, it makes more sense to plan than to wait. But
100%.
But you did mention that there are times when even with powers of attorney in place, And with that plan in place, there is a need for guardianship. So when is that? At what point does my power of attorney not work?
So, kind of something we already touched on. So if your power of attorney isn't as comprehensive as it should be, so maybe it doesn't give the power of attorney the authority to sell property, or enter into new contracts to purchase property on the agent's behalf. They couldn't do those things, but you want to sell your house, but you don't have the capacity to do that. So if a power of attorney isn't as comprehensive as it should be, it sometimes is a hindrance. In other cases, you have a power of attorney in place, and kind of back to the difference that I talked about earlier, the person creating and appointing the power of attorney gives that agent authority. So if I am making you, Anna, my power of attorney, I am giving you the authority to act on my behalf. However, I have retained the authority to terminate or revoke the power of attorney I just put in place. And so then you would no longer have power. So that grant of power makes a difference, but I can still function like a normal person. So if I give you power of attorney, I can still bank for myself. I can still enter into land sale contracts and buy and sell property or invest. If I want to buy a little bit of GameStop stock, I can. But no, so I still have the authority to do those sorts of things. You cannot prevent me from doing any of those daily activities that you do now. Whereas a guardianship can prevent a person from doing something. And you ask yourself, well, why might I need to trump a power of attorney and still get guardianship? The example I give to most of my clients is, we had a gentleman a couple years back who was the power of attorney for his brother. So he was helping him pay his bills, he was banking, he was making sure rent was paid, all of that sort of thing was taken care of. But because his brother still had access to his accounts and the authority to use those accounts, his gambling problem kind of got the best of him. And so he would ask strangers, because his brother didn't live locally, he would ask strangers to pick him up from his facility, take him to the ATM, and then to the casino. And sometimes he would get out extra money for those folks that had done that for him. Or in other situations, he would just get plain robbed, putting himself and his health in harm's way. So in that particular case, yes, my client could do his banking and make sure rent was paid, but he couldn't prevent his brother from getting in those dangerous situations. And so a guardianship was needed to ensure that his brother was getting the care he needed and wasn't being taken advantage of. So does that kind of make sense as to why, yes, you might have a power of attorney, but you still need guardianship?
Yeah, absolutely. That makes sense. Well, this is these virtual cafes are like so much information packed into just a few minutes. And I look forward to continuing this conversation throughout this month, because when it comes to guardianship, there are a lot of questions. And it's never an issue to go over those questions a few times to help them stick. And so I really look forward to doing these virtual cafes with you this month. And I appreciate your time today.
All right, I appreciate you having me on today, and I look forward to continuing our conversation into the nuances and different things or ways to navigate guardianship. So I look forward to our next installment.
Yeah, that's right. And our next topic is, so I've been appointed guardian, now what? And I think that's going to be a very complex topic, but gosh, I think it's going to be a good one. I
hope so. I hope it kind of gives folks a roadmap of, if you need guardianship, what do you have to look forward to in terms of getting appointed as guardian? Or, okay, you, in this particular case, you've become guardian of someone. Now what the heck do I do? Because there's a lot to do. So if we can hopefully help folks kind of navigate that, give them a little bit of a roadmap, I think that would be really helpful.
Yeah, I completely agree. Well, thank you again for your time today.
All right, you have a great rest of your day.
Yeah, I'll see ya.